order for a contract to be a contract, it has to include some basic elements. It has to have the parties. It has to describe the material terms, and
why were those lacking on the signed check? I guess I need
contract?
to know. Can you flesh out for me what's on the signed check?
Well, who is going to be the lessee? Where is the property? What is the work to be performed? Who's going to be paying for that work? When is the move-in date?
And none of that's on the check.
None of that's on the
What is on the check? Tell me what's on the check.
I don't have it with me. I think it's just a cashier's check with a dollar amount. I think there is something in the memo line to the effect of
ERDA property.
ERDA property.
Okay.
So, Your Honor, a check is a negotiable instrument, and it's also not signed by. When she endorsed it, she was endorsing it to deposit. She wasn't endorsing it because she agreed with all the material terms, because the material terms were not on that document. Now, the challenge is that counsel, I think, had just made my argument, my case for me when he says that the only lease, the only document to be signed in view was never going to be signed because it was onerous and because one side drafted it. Well, the law requires that you have a signed document. That's the purpose of the statute of frauds is, as counsel correctly notes, I think it's to make sure that everyone's on the same page as to the material terms. Because real property tends to be very expensive and it's immovable and it's governed by documents that are recorded and maintained by the county. And so if you want to create an interest in real property with some few exceptions, you have to have a written document. The written document has to include the material terms. And for it to be enforced against a party to be charged, it has to be signed by the party to be charged. So there's a laundry list of issues that establish that there was no meeting of the minds. Counsel referenced work to be done. He says that there's questions. I'm sorry.
I'm sorry, and I want you to finish go ahead and finish your thought there, and I'm going to move you to a certain question.
Okay, he says there was a $517,000, but apparently that was still in dispute because there were improvements to be made, and were improvements going to be taken out of or in addition to? We don't know because the parties never reached an agreement. The date of availability, and so on. If these are the terms that he's saying we didn't sign it because these terms were not established, then by definition there was no meeting of the minds ever. And that being the case, respondents can't say there was an agreement, because first of all there has to be a meeting of the minds, and by their own legal arguments there wasn't a meeting of the minds. Second, the statute of frauds says that particular type of agreement has to be in writing and signed, and it wasn't.
Okay. So I'm looking at Utah Code Section 38-9-205, subsection 4. So there's a petition. Petitioner has filed a petition, Nullify Lien, in front of me. Subsection 4 says a summary proceeding under this section, A, may only determine whether a document is a wrongful lien, and B, may not determine any other property or legal rights of the parties or restrict other legal remedies of any. What subsection 4B tells me is this is not the time or place for me to decide all of the issues that are being brought here in terms of the complexities of this issue, in terms of rights and remedies, etc. Right? This is very limited in scope. And so what I want to make clear is I'm not deciding everything in terms of the rights of the parties and the remedies to the parties. I'm looking at 4A, and then I may only determine whether a document is a wrongful lien. And what I'm looking at is under the statute. Here's my question. What would you have the court look at to make sure that I'm only complying with 4A and not moving into 4B? And what I mean by that is if I'm only to determine whether the document is a wrongful lien, what I've heard you indicate to me is that I can find that it's a wrongful lien by the mere presence there's no contract here, and statute of frauds is implicated. That's what I've heard you say. What I've heard respondents say is I can determine that there's not a wrongful lien because I have a check here, a signed check with your client signing the check. So my question to you is, you're both having me look at different considerations in terms of whether 4A is satisfied. Why should I require a contract? Why does it require a contract, a signed contract on the issue of the wrongful lien? Can you flesh that out for me? I can ask the question a little bit more clearly if it will help. But what I'm looking at is making sure that I'm squarely within 4A and not 4B, and that I am looking at what are the considerations the court should look at when it is a wrongful lien. Does that mean that I'm requiring a contract in terms of answering the question of whether there's a wrongful lien, or does that get into the issues of 4B and whether or not what the property rights are? Can you answer that question for me? Does the question? Let me ask you. Does the question make sense here?
It does, Your Honor, and I appreciate it. I think it does. I see what the court is asking.
I'm very focused on the language of 4A versus 4B, and that I am not today to determine the rights, the legal rights to the parties and everything that's being brought to me. I am in narrow scope right now. The statute tells me to narrowly look at whether, in this case, the notice of intent is a wrongful lien. And I'd like you to flesh out what considerations should the court be looking at for that.
Okay. Well, I think in order to apply that statute, that provision, subpart A, the court has to understand what a wrongful lien is. We have to understand, well, in order for me to determine if this is a wrongful lien, I have to know what does the statute mean by wrongful lien.
And you have emphasized for me with that there's no document signed by the owner. Did I understand that correctly?
Yes, and more particularly, Utah Code 38-9-102, subpart 12.
Give me the code again,
38-9-102.
I'm going to pull that up here. Hold please. (38-9-102).
Yes, subpart 12.
I'm there. Go ahead.
Okay, so it says, quote, wrongful lien means any document that purports to create a lien, notice of interest, or encumbrance on an owner's interest in certain real property. That's the first part. So I think the court can, for the purposes of this hearing, look at the notice of interest and say, does it meet that part of the definition? And I think it does, because it specifically calls it a notice of interest. The next part says, and at the time it is recorded is not, ... down to subpart C, signed by or authorized pursuant to a document signed by the owner of the real property. So the court has to step back in time, and it's actually relatively simple. All the court has to do is step back in time and say, well, when was the notice of interest recorded? And it's on I think it was the same day, January 8th of 2021. Was there in existence a document that was signed or authorized pursuant? Was it signed by or authorized pursuant to a document signed by the owner of the real property? Was there any document in existence signed by my client that is sufficient to meet this meaning of this definition of a wrongful lien?
And why would the check not be sufficient to meet that requirement?
Well, because the notice of interest doesn't mention the check; it mentions the option agreements.
And so I want to make sure I understand what it is signed, and what you concede is a check by your client, but nothing else is signed by your client. Do I understand those facts correctly?
That's correct.
And so wrongful lien means any document that purports to create a lien, notice, interest, or encumbrance on an owner's interest in a certain property, and at the time it is recorded is not signed. And so you're saying the notice of interest specifically here is not signed by your client, and therefore the requirements of 12C fail. Did I follow that argument?
Well, yeah, it can fall to one of two ways. It either needs to be signed by my client, or it needs to be signed. It needs to be authorized pursuant to a document signed by my client. So there can be a separate document, but there's nothing in the check that says yes, you can record this notice of interest. In fact, the notice of interest isn't predicated on the check. It's predicated on the lease. And the lease was never signed.
So you're saying the lease is not signed. There's, number one, there's no contract signed. There's no lease signed by your client, and the check is signed, but the check is not sufficient for what's required under 12C, given the fact that the check lacks material terms. Did I follow that correctly?
Yes, and I would add to that, Your Honor, that my client's testimony would be that she agreed to the notice of interest and she cast a check in anticipation of the lease option being signed at the same time. In a sense, we would submit that is a form of fraudulent inducement because it was never signed, and apparently there was never an intention to have it signed.
I understand your position there. Thank you. And let me have you respond to then the arguments, though, by Respondent that the notice of interest was created by Petitioner's agent. So again, I'm being asked to look at a totality of things. Not only was a check signed by your client, the check changed hands. The notice of interest was created by Petitioner's agent. What's your response to that?
Well, yes, she or Your Honor, I would proffer that Martha Johnson, a security title, was the person who actually created the document. But the notice of interest was prepared at the request of my client. She was doing that as an accommodation, as an assurance to the lessee, saying, yes, look, I understand that a lot of money is about to change hands. You're binding yourself to this lease, but you don't have a recorded interest. So here's a document that creates that recorded interest. The things that were supposed to happen is here's the check, here's the notice of interest, here's the lease. These were all intended to be done in tandem, and one of them was deliberately withheld. That's just a big problem. Okay. So I'm sorry. You wanted me to address? You answered my question. What I was looking for is the interplay of the statute 38.9-205, 4A and B, subsection 4A and 4B, with the interplay of the statute, the 12. And what I want to do is I am going to give Mr. Beckett you an opportunity to answer that same question. I still will give you the last word, but I really wanted to make sure I understood counsel's position on the interplay of this two statute provisions I'm looking at, 38-9-205, subsection 4A and 4B, as well as 38-9-102, subsection 12, and specifically 12C. That's what I was looking at here. Is there anything else you would like to add to that inquiry that I have there? Yeah, I guess a few particulars, Your Honor. The lease option has signature lines. So I think it's dissembling for the respondents to say, well, the endorsement on the check is close enough for jazz, is close enough to make this agreement. It counts as a signature on the lease option, both because it's not true, because it has signature lines. Clearly the parties were intending to sign that document. Also, the testimony proffered here today is that they were never planning on signing that document. So for that reason, we're still left with a statute of frauds issue and a lack of the meeting of the minds and the other bases that we previously recited. Thank you. I understand your position there. Mr. Beckett, it was in Mr. McDonald's last argument that you saw a series of questions I had. I do want to understand the parties' positions on the interplay of the statute provisions I'm looking at. Would you like to comment to that? Yeah, Your Honor, I do. Specifically on what a wrongful lien is, specifically as the court read it out, is at the time it's recorded, right? At the time it's recorded, not signed. Counsel was referencing, well, on January the 8th, the notice of interest was signed. Yeah, that doesn't matter. What matters is when it was recorded. And when it was recorded after
Holly Jones had deposited a check into her bank account, endorsing the back of it, acknowledging that she had received funds for the IRTA property. Does that justify the basis for recording a notice of interest? And the answer is yes. She signed a check for $225,000 that says Skull Valley re-IRTA property. She knew what it was for. She deposited it, coming here and saying, oh, you know, that was for the other IRTA property, or whatever arguments there are. The reality is this was for this property. And the thing that counsel is advocating then is, well, that notice of interest should have then been amended to say, instead of option agreement, and it's not a lease agreement, it's an option agreement, which didn't identify my clients and had terms that were not agreed to and continued to be negotiated over time, which is referenced in the text messages which petitioner provided. The only question is, by the fact that she signed the check, accepted the money, and then the interest was recorded, was that interest recorded wrongfully? And the answer is no. There's no way to twist the facts otherwise. She took money for a piece of property, and she said, here's a notice of interest, it will protect your interest. So your $225,000 is not actually a gift. And it wasn't a gift. And that's what petitioner is asking for this court to say. It was a gift, take off the notice of interest off the property. And it wasn't. At the date of recording, she had already accepted the money. She put it in her bank account and went to work. And then she used that money to make modifications to her property after the notice of interest had been filed. And she knew it was filed. And then it took until 10 months later, 12 months later, before she said, whoa, that's wrongful because now I want to sell the property to somebody else and make more money. And that's not rightful. The interest was recorded correctly after she took money on the property. And that's all this court needs to consider. The court doesn't need to consider whether or not there was a contract that effectively transferred the ownership one way or the other, or the material terms. And what's a material term? Because in every contract, some people believe one term is material, some people believe another term is material. Together, they end up becoming the material terms. All we need to know is the property and the price. And we knew the property and the price was agreed at $517 with a $75,000 remodel budget, and my client paid $225,000 to secure that purchase price and the remodel. But we get that by looking at everything else outside parole evidence, right? This goes back to law school again, right? And what can we look to? And all we're asking this court to say is that this recording was not wrongful because it was secured by a check that was signed by the petitioner.
Thank you. I understand your position here. And as I mentioned, Mr. McDonald, you do have the last word. I'm going to have you hold here for a minute here. All right, thank you. And Mr. McDonald, if do you have any responses to what's been argued? I have some extra. I want to find out where our extra noise is coming from, and we can pause that so it doesn't distract you.
It's coming from me, and I'm trying
That's okay, and take the time that you need to. Thank you. All right, and Mr. McDonald, I reading and rereading that the statute 12C, and I'm looking at that language. At the time it is recorded, is not signed or authorized pursuant to a document signed by the owner of the real property. And again, I take petitioner's argument that there's just simply no contract here. There's no document signed by the owner of the real property. That is petitioner's stance here. Respondent is emphasizing to me there's certainly a document signed by the owner. It is the check. And not only is the check signed, but that your client received the monies and that would satisfy 12C as a document signed by the owner, that supports the notice of interest. And so again, I'm looking at what is the pertinent language I have to look at. Signed by or authorized pursuant to a document signed by the owner. So why isn't it sufficient that a check is signed and that your client cashed the check?
Well, a couple of reasons, Your Honor. First, when the transaction appeared to be, stalling, this was quite some time ago, my client said, look, this isn't working out. Let me know how to return the money. There have been repeated efforts to that effect since then, and they've all been uniformly refused. So my client has retained the money because they refused to take the money back. Now I'm going to be making a motion with this court, we can't do it at this hearing, to deposit it into the court's account for a proper adjudication of who's entitled to that money, because there's attorney's fees and there's damages under the wrongful lien statute and so on. But to answer the court's question, the notice of interest doesn't mention a check. In fact, it is quite explicit that it's based on an option agreement. Well, that option agreement is not signed. It's a legal nullity. It does not exist. There is no document signed by the party. I don't think the respondents can say the notice is based. The notice of interest itself is based on the option agreement. Please ignore the option agreement. That's what the respondent's position is. And
the option agreement is not signed by your client.
Yeah, and it's not signed. Therefore, it meets the statutory definition of a wrongful lien. Opposing counsel made some arguments about material terms, but I think the material terms can be admittedly somewhat squishy. But there are virtually no material terms on the check. To call the check, which is a negotiable instrument, I mean it's an instrument used to transfer money. It's not something in and of itself that identifies with any particularity the property. It doesn't identify the lease term. It doesn't identify the parties. It doesn't identify the closing date. It doesn't identify the improvements to be made. Given that the parties never actually reached an agreement on those things, I'd say those by definition are material, because that's the reason why the document wasn't signed. If those had been trivialities, then I think we wouldn't be having this discussion. And so, Your Honor, to the extent that the counsel suggested that this would be unfair because $225,000 turns into a gift, not sure where that came from. We've never made that representation. We instead, my client has repeatedly attempted to return it without success. More to the point, the ramifications of not releasing the notice of interest are pretty severe. My client has a hard money loan encumbering this property. She can't refinance it as long as there is a cloud on title. And under the statute, we believe that we have complied with each provision of the wrongful lien statute, and we're entitled at a summary proceeding to have it released. If there's going to be some claim for specific performance as a counterclaim, that's fine. That's water we haven't gotten to yet. But for the purposes of this hearing, we would submit that we've established that the notice of interest is not falls within that last provision of the statutory definition of wrongful lien and should therefore be released.
Thank you, Mr. McDonald. All right. Before the court is the petitioner's petition to nullify lien. I am ready to give my ruling on this. I am going to emphasize once again the quality of the arguments that have been presented to me by both counsel here. Mr. McDonald, Mr. Beckett, you have served your clients well here in the arguments here, and I found your arguments today incredibly helpful. Thank you. So here's my ruling here. I am granting the petition to nullify the lien, and in doing so, I am applying the plain language of Utah Code 38-9-205 and 38, and also pertinent provisions including 38-9-102, And I'm going to start with 38-9-205. According to that, in subsection 4B, what I am not to determine today are the property or legal rights of the parties or